Welcome to the WVU College of Law 2013 McDougall Lecture. We are privileged to have with us today Justice Walter Echohawk of the Supreme Court of the Pawnee Nation, who will share with us his path-breaking lecture, The Rise of Human Rights in Native America. Today, Professor Bonnie Brown will introduce Justice Echohawk, but before she does, I will take just a moment to tell you about the important role Professor Brown plays at WVU. Professor Bonnie Brown is a graduate of Iowa State University and the University of Texas at Austin, and previously taught at the University of South Dakota. She originally joined the WVU faculty in 1996 as an assistant professor of journalism. However, her career led her in the direction of her passion, and in 2001, she began working in the Native American Studies program in the Eberly College of Arts and Sciences, with a deep commitment to raise the image and the knowledge of Native Americans at WVU. Since 2005, she has played an absolutely critical role leading the coordination of the Native American Studies program. Her contribution to this program cannot be underestimated. Professor Brown has developed and taught numerous courses in Native American Studies. When I read the list, you'll feel the way I did when I read them. I want to take every one of them. They include contemporary Native American issues, Native women in leadership, and sovereign tribal nations. However, and she's currently leading a seminar actually based on Justice Echohawk's book. The seminar is called In the Courts of the Conqueror. That's the course I'd really like to be in right now. But she wasn't content to just keep the classes within the boundaries and walls of WVU. Her legacy includes organizing regional symposia, such as Healing the Earth, Healing Her People. Who Speaks for the Dead? Kin, Science, the Law, Telling the Stories, American Indian Interpretation in the Trans-Allegheny region. To spread the news about the critical role of Native Americans, she directed the West Virginia Native American Studies Teacher Institute, a crossroads of Native culture and history, examining the Native heritage of West Virginia and the region, and is coordinating an upcoming grant-funded service project at Grave Creek Mound Archaeological Complex. Recognizing her passion for justice, she received the 2012 Neil Bucklew Award for Social Justice, which is given annually for outstanding leadership, courage, and support in the area of social justice at WVU. I thank Professor Brown for all of her work in building the Native American Studies program for us and for bringing Justice Echohawk to WVU. She will now introduce our guest.
Thank you, Joyce. That was a very nice introduction. I have to, however, acknowledge that all of those accomplishments are only possible with the contributions and support of our faculty on the Native American Studies Committee and with my predecessor's help. Elisa High, who's the former coordinator of Native American Studies, and Ann Patterson, who's also a previous coordinator. They continue to inspire me and support me in that role, as well as many of our faculty, alum, and students who are here today. So thank you very much, Dean McConnell, and thank you, Dr. Lofazo, for helping to coordinate today's event, and faculty, staff, students, and community guests. It's so nice to see all of you here to share in this special occasion. I am so pleased to welcome Mr. Walter Echohawk to campus as our 2013 Native American Studies Elder in Residence, and to introduce him for this McDougall Lecture. Perhaps some of you went online to read more about Mr. Echohawk in anticipation of hearing his remarks here today. If you Googled his name, you learned that he is and has been for some time a very busy guy. There were 2.5 million hits when I Googled Walter Echohawk. So that's a lot, yeah. Indeed, his accomplishments and contributions are too numerous to list here, but I will share a few. As Dean McDougall said, he serves as one of 5 Pawnee Nation Supreme Court justices. He is an activist, scholar, artist, professor, and for more than 35 years worked as a staff attorney with the Native American Rights Fund, whose motto is, "We never give up." I'm continually inspired and impressed by the work of the Native American Rights Fund, and truthfully, they do never give up. Founded in 1970, the Native American Rights Fund is the oldest and largest nonprofit law firm dedicated to asserting and defending the rights of Indian tribes, organizations, and individuals nationwide. It's concentrated in 5 key areas: the preservation of tribal existence. There are 565 federally recognized Indian tribes in America today. The protection of tribal natural resources, the promotion of Native American human rights, the topic of his talk today, the accountability of governments to Native Americans, and the development of Indian law and educating the public about Indian rights, laws, and issues. I first became acquainted with his work and witnessed his prominent leadership through my attendance at the annual National Congress of American Indians, the oldest and largest organization of American Indian tribal leaders. It's been my privilege to listen to his insightful, eloquent comments on resolutions dealing with such important issues as religious freedom, sacred places, cultural protection, and NAGPRA, the Native American Graves Protection and Repatriation Act of 1990, which he was instrumental in developing and passing, among many other important laws. Walter Echo Hawk is a successful author. I've assigned his current book, In the Courts of the Conqueror, the 10 Worst Indian Law Cases Ever Decided, to my seminar class. And it amazes me he could boil all the horrible cases down to 10. So that's an accomplishment in its own right. One student admitted, after reading just the first few chapters as assigned, "I never thought I'd have a textbook that I couldn't put down." And we've had such a positive response that I'm really happy to have been able to enroll students in this seminar and proceed. Mr. Echo Hawk will be helping us out throughout the semester with some Skype lectures, and he'll be back on campus in April for a full week. I feel certain that you'll agree with my students and me. Mr. Walter Echo Hawk has a gift for taking the complex tangle of history with its racism, oppression, and greed, what he calls the dark side of federal Indian law, and weaving an informative, coherent, inspiring argument for rooting out the lingering injustice and advocating for the law to serve as a shield instead of an instrument of harm used against America's indigenous peoples. Please help me welcome Mr. Walter Echo Hawk.
Wow. I really appreciate that very kind and generous introduction, Professor Brown. And good afternoon, everyone, and welcome. I'm very glad that you have braved the snow and weather to be here with me today. I want to thank the West Virginia College of Law and Dean McDougall, as well as the Native American Studies program, and especially Bonnie Brown for making my appearance here today possible. I'm very, very happy to be here in Morgantown to see the beautiful, I think, America's best kept secret. It's very pretty here, and I'm looking forward to coming back this spring. And to be here on this beautiful campus, on this pinnacle overlooking the city, you know, at the citadel of the law here. It's just wonderful to be here. And I appreciate the many kindnesses that have been extended to me during my short stay here so far. But above all, I think I'm very deeply honored to be a part of this distinguished McDougall Law Lecture with its global and international perspectives that it brings to the law. My topic, or what I'm going to be talking about today, is federal Indian law, and I'm going to be focusing on its international dimensions of federal Indian law, which is that body of law that pertains to America's indigenous peoples, that is our American Indian tribes, our Alaska Natives, and even our Native Hawaiians. As was mentioned, I've really enjoyed the privilege of a lengthy career in the law, and I've had the opportunity to provide legal representation to American Indian tribes and Alaska Natives and Native Hawaiians, over the span since 1973. And, excuse me, today I continue to practice law in the state of Oklahoma. I'm no longer a staff attorney with the Native American Rights Fund, but I work with the law firm of Crow and Dunleavy in Oklahoma, which is the state's largest law firm, and serve as one of the tribal attorneys for the Comanche Nation, as well as doing legal work for about a dozen other tribes in our state of Oklahoma, and have the opportunity to serve on some of the tribal courts there in the state. But in recent years, as my legal career starts to wind down, I've been more and more interested in sharing some of my perspectives that I've gleaned in my practice over the years about federal Indian law through writings and books and public lectures. And so I'm very pleased to be here. And my topic today is the rise of human rights in Native America. And my premise for this talk is that our existing legal framework here in the United States pertaining to Native peoples, that is federal Indian law, is almost completely bereft of any human rights discourse or any human rights principles. And in fact, if you read the four corners of the cases in this field, you'll find almost no discussion of human rights when it comes to defining the political status, the land rights, the cultural rights, the civil rights of Native peoples here in the U.S. There's no discourse on human rights. And in fact, the landmark cases expressly eschew looking at abstract notions of justice, when defining Native American rights. And this amoral body of law has really produced an amazing prevalence of unjust cases pertaining to Native American history, Native Americans in American legal history. But today is a very historic time in federal Indian law because we now stand at a crossroads between two distinct legal frameworks for defining Native American rights. One framework being the old framework, that is our existing federal Indian law, which came to us from the law of colonialism adapted to the American setting. And a brand new framework, a human rights framework, which comes to us from the United Nations Declaration on the Rights of Indigenous Peoples. And so as a result of this UN declaration, which was approved by the General Assembly in the year 2007, and is currently endorsed by 150 nations, including the United States in the year 2010, we can see a brand new legal framework for defining indigenous rights as a result of this UN declaration. A human rights foundation that is based upon or derived from a more just foundation for indigenous rights, based on values of justice, equality, non-discrimination, democracy, and good faith. Then the value system that produced in the 19th century federal Indian law, which was based on notions of colonialism, racism, conquest, and that sort of thing. This is a historic time, I think, for practitioners of federal Indian law, and I think that the challenge of law students and law scholars, tribal attorneys, students, as well as tribal leaders, is to try to synthesize the very best, most protective and just features of federal Indian law with that of the new human rights framework, and then to stride towards implementing this UN declaration into the law and policy, social policies of the United States. And so I think it's very, very timely for lawyers and scholars and students, tribal leaders, to begin a focused national discourse into the nature and content of human rights for Native Americans, a discourse that our country has never engaged in, and see where we can strengthen our existing legal framework and begin viewing our Native American rights as inherent and inalienable human rights. So what I want to do today is to examine briefly both legal frameworks for you. And by necessity, I'm going to have to brush with fairly broad strokes here, so forgive me for that. But first, I'd like to review with you the old legal framework, that is, the existing body of federal Indian law. Here in the United States, we are fortunate to have a very complex and comprehensive body of law pertaining to indigenous peoples in federal Indian law. This body of law, well established through the Constitution and innumerable Supreme Court decisions, Title 25 of the U.S. Code, is essentially a body of law that has come to us today, that we've inherited from the law of colonialism that was adopted a long time ago to fit the American setting. And there are two sides to this body of law. On the one side, we can see a very vibrant set of protective features that do serve to effectively protect the well-being and political integrity and cultural integrity of the American Indian tribes. And this is a very strong set of legal features that can be found in federal Indian law, and especially sometimes joined with other bodies of law to make very potent tools for protecting tribal interests. And over the decades, and especially during the modern era, beginning in about 1970, Native America has really tried to make the best of this framework during the modern era of federal Indian law up to the present day. And that is, we haven't attacked this legal framework. We haven't attempted to overturn a lot of the very nefarious doctrines or cases that I would have to call miscarriages of justice, but rather we've lived with them and tried to focus and emphasize these protective features in federal Indian law and coax the courts into applying them in a modern-day setting. On the other side of the coin, however, we have this dark side of federal Indian law. that is characterized by a number of nefarious legal doctrines focusing on unfettered colonialism, notions of race and racism, unjust legal fictions. These nefarious legal doctrines that were embedded in our body of law have really served to produce a pretty substantial body of unjust decisions which amount to some structural weaknesses, I think, in federal Indian law today, and make our Native American rights ever vulnerable to being weakened, by the courts at will. And this has resulted in a number of tensions within the body of federal Indian law between the dark side of the law and then the protective side of the law. The various judicial trains of thought sometimes are at odds with one another within this body of law, as the protective side confronts the dark side of the law. And as was mentioned earlier, I studied this conflict and attempted to understand the forces at work in the dark side of federal Indian law in my book, In the Courts of the Conqueror. And I believe there's going to be some time later after the lecture to sign a few books, sell and sign a few books here from compliments of the bookstore here. Secondly, I want to introduce you to this new legal framework this morning or this afternoon, to direct your attention to this UN Declaration on the Rights of Indigenous Peoples. It has roots in modern international human rights law, and I want to discuss, how it repudiates the dark side of federal Indian law here in the United States, how it serves to reaffirm the protective features of federal Indian law and the very best of our legal culture as it pertains to Native Americans, and could potentially strengthen United States law at its very best and in its finest hour as it has applied to Native peoples. And then thirdly and finally, I want to just flag some of the challenges I think that lie ahead in terms of implementing this UN declaration. I think it's not a self-executing treaty. It's currently not legally binding and enforceable in U.S. courts. It's merely a declaration of international norms and emerging norms and how they should be applied in the unique context of indigenous peoples that needs to be affirmatively implemented into United States law and social policy through smart litigation, through legislative changes and administrative changes. So I want to just sort of flag some of the challenges in implementing this wide-ranging set of UN standards into our domestic law and policy to help us move away at long last from the dark side of federal Indian law and the law of colonialism that is found there to a more just human rights foundation for defining the rights of American Indian tribes and Alaska Natives and Native Hawaiians. Hopefully we'll have some time for questions, a few questions, and then we'll sign a few books. I know a lot of you law students can't afford books and stuff like that, but I think they're in paperback, but that'll help. That should help. So let me turn to my first task here, and that is to take a look at the old framework, or i.e. our extant body of federal Indian law here in the United States, To really understand federal Indian law, I think you have to have a backdrop or a context for understanding its evolution. And the pertinent backdrop is that of European colonialism. As we know, from 1492 to about 1960, the human race was living in the colonial era, where the nations of Europe competed with one another or among one another to colonize as much of the rest of the world as possible. And so during this 450-year period, all of the Western Hemisphere was colonized. All of Africa, most of Asia, India, subcontinent of India, the Pacific region, the circumpolar world, were all subjected to European colonization. For the indigenous peoples that resided in these areas, colonialism had very harsh impacts because it invariably meant the invasion of homelands, the appropriation of natural resources, the destruction of indigenous habitats, the subjugation of native peoples, the loss of a nation, if you will. This persisted. It was a universal phenomena for almost 500 years across the planet. And it's left a legacy of colonialism that is still embedded in many of the legal and social systems of the former colonies around the world today, including in our own land. We can see the law of colonialism, for example, deeply embedded in federal Indian law. So I want to just focus, again, by way of backdrop, just a little bit on the law of colonialism, of early international law. I think the purposes of early international law were to govern the relationship among nations, among the nations of Europe, and to lay down the rules for colonizing the Americas, or non-European lands, and which was done at the very dawn of the colonial era, through early notions of international law of the day. That body of law was not accountable to indigenous peoples. They were excluded from as subjects of international law, which was limited to only the external relationships among nations, and it excluded the indigenous peoples that had been engulfed, by the European colonies. And so it was not accountable as it developed over the years to indigenous peoples in the colonized lands. These rules serve to justify colonialism, to legitimize the acts of colonialism, and it can be a dirty little business to appropriate someone else's land. But these principles made that perfectly legal. And some of the attributes of the law of colonialism found in early international law included the doctrines of discovery, doctrines of conquest, the just war doctrine, with its so-called reasons to go to war against indigenous peoples, notions of guardian or trusteeship found in most colonies, which basically means I own your property and can do with it as I please, notions of principles of guardianship, notions of racism and cultural superiority, notions of plenary power when it comes to governance. These are principles that can be found in the law of colonialism and in colonies around the world, the legal systems in these colonies around the world, that were embraced by not only their colonies, but often their progeny, the new emergent settler states, that do still linger in many places around the world today. Colonialism was repudiated, however, shortly after World War II, with the decolonization movement around the world. And then in 1960, the UN passed the decolonization resolution that condemned colonialism as being unjust. But that legacy is still alive and well in many places. And this law of colonialism and colonialism itself has left a legacy of colonialism and a heavy influence on federal Indian law. Now, let me just take a moment to define federal Indian law. It is a body of federal law that pertains to the bundle of treaty rights and political rights and culture rights, religious rights, natural resource rights of Native peoples, or American Indians and Alaska Natives principally. This body of law is founded on not on race, but on the political relationship between Indian tribes and the United States government. The sources of federal law are quite diverse, and I just want to list them for you. The first source that gave rise or contributed to the development of federal Indian law, first and foremost, is international law. Had a heavy influence on federal Indian law here in the United States. The idea of treaties came to us in whole cloth directly from international law, and we have 369 treaties with American Indian tribes here in the United States that were entered into by the executive branch and approved by two-thirds Senate approval pursuant to the Indian Treaty Clause of the U.S. Constitution. The doctrine of inherent tribal sovereignty came to us from international law. The protectorate principle of Worcester v. Georgia, i.e. the idea that Indian nations came into the Republic through their treaties under the protection of the United States, with a protectorate relationship between the Indian nations and the United States, as found in international relations, where a weaker nation goes under the protection of a stronger nation, with a duty to protect the well-being and integrity of the protectorate. The notion of trusteeship came to us from Victoria's Law of Nations, as well as guardianship. The doctrine of discovery came to us in Johnson v. McIntosh, directly from international law, to define the land rights of the Indian nations. Notions of conquest, as well as, that are found in federal Indian law, as well as the plenary power of doctrine of Congress to legislate in Indian affairs, came to us also from the insular cases as a part of applying the same power of Congress to govern our foreign colonies to the reservations here at home. The second body source of federal Indian law are our treaties that I mentioned to you earlier. The third is the U.S. Constitution, which includes the Indian Commerce Clause and the Indian Treaty Clause. The fourth are Supreme Court decisions, and there's hundreds of them. Each year the court decides one or more Indian cases. There are statutes. Congress has passed thousands of statutes pursuant to its plenary power that fill the entire code of Volume 25 of the U.S. Code. Executive orders are another source of federal Indian law. Administrative law, the rules and regulations and policies of federal agencies. And then finally, tribal law, the laws enacted by the Indian nations. All of these sources form the current body of federal Indian law. It's a thorny thicket for the person that doesn't practice it. Many of the principles in there are anomalies. For example, the landholding rights of the land rights, or the way land is held by tribes in federal Indian law, you find no counterpart in our common law. Same way with water rights, there are no counterparts for the reserved doctrine of reserved Indian water rights. But all of these principles and doctrines are organized in a systematic way, in coherent way, I should say, in Cohen's Handbook on Federal Indian Law, which is now in its, I think there was a recent edition in 2012 that came out in that. But essentially you'll find in there, in this body of law, 3 lines of judicial thought. Again, the law of colonialism is a predominant train of judicial thought that you can see in the cases. Secondly, you see it carried to its extreme in this law of conquest of Johnson v. McIntosh and the Tehatun case, carrying the law of colonialism to its extremes, I would think. And then the third line of judicial line of thought is this inherent tribal sovereignty and protectorate principles, Worcester v. Georgia, that tends to mitigate the more harsh edges of the law of colonialism and the law of conquest. These 3 lines of thought, there's often tension between them, and but all told, within this framework, from about 1970 to the present, we've seen the great social movement in this American Indian tribal sovereignty movement that has literally produced the rise of the modern Indian nations that we see today. Look around the country, we see this everywhere. Indian nations firmly fixed in the American political and social landscape, and where our tribes have undergone striking nation-building advances in the last generation, all done within this legal framework as Native America reclaimed its sovereignty, its self-determination rights, its land and culture and pride. But in recent years, I think that this movement has faltered due to on the very doorsteps, I think, of true self-determination as defined by the United Nations. As a result of this dark side of the law that I mentioned earlier, we see a current Supreme Court trend since the Rehnquist Court and into the current Roberts Court, where Indian nations have lost over 80% of their cases that come before the court. In some terms, losing 88% of the cases. This statistic means that prison inmates fare better in the Supreme Court than our Indian nations. That trend has really worried legal scholars and tribal leaders, to ask, is federal Indian law dead? Secondly, we see, as I mentioned earlier, an amazing prevalence of unjust cases in our body of law. And how do we account for that, Because we expect justice in our American legal system. It was intentionally designed to achieve justice, through our rules of procedure, our judicial ethics, our criminal procedure, appellate procedure, attorney ethics. We reasonably expect justice when we go to court, don't we? And I think we see it most of the time in 99.9% of our cases, but it is, after all, a human institution and therefore fallible. And we have seen very severe, I think, miscarriages of justice in American legal history that do occur when we see the law at its worst, I guess, in the slavery cases that went before the Marshall Court, upholding the institution of slavery, the Dred Scott decision, where a slave, went to federal court to challenge seek his freedom for him and that of his family. And the Supreme Court saying no access to the federal courts because the founding fathers considered blacks so racially inferior that they did not intend to allow them to use the courts. Plessy v. Ferguson and its invidious separate but equal doctrine. The Korematsu case, where the Japanese-American race was incarcerated during World War II, summarily, without any hearing whatsoever. These cases, if you read them, they were written by the finest legal minds of the day. They contain compelling logic, make you want to go out and get a slave or something. They're very persuasive. But they had produced a manifestly unjust outcome. Well, these only come along every once in a while, but we see them in Indian cases. In my book, the 10 worst I picked 10 and analyzed them in my book. Johnson v. McIntosh for defining land rights. Cherokee Nation importing these notions of racism and embedding them. The Lone Wolf decision on the plenary power to break treaties. The Sandoval decision, for extending federal power over tribes based on notions of abject racial inferiority. The Teton decision, doctrine of confiscation of Aboriginal land. The Ling case in 1988, denying any First Amendment protection for a holy place located on federal land. The Smith case being another example in 1990, where I went to the court twice as a part of the argument team regarding that peyote religion, our old and venerated Indian religious use of peyote. These are cases that are still the law of the land. They've never been reversed like all of the slavery and all of the other cases I alluded to earlier. And in these cases, there's no human rights discourse. You'll see in the opinions that the court's disclaiming or eschewing these abstract principles of justice. We have to just apply the law and the social mores of the time. We can't get into a debate about whether this is just and unjust. Producing an amoral body of law. An amoral body of law. And so this, to me, bespeaks the need for law reform and the need to replace some of these outmoded, nefarious legal doctrines with ones that are more just, ones that are more in keeping with our core American values, ones that are more appropriate in a post-colonial world. Our Supreme Court should not decide Native American cases based on race long after that's been discarded by the rest of society, or unfettered colonialism in our democracy, or notions of conquest. I think we have far more legitimate bases to govern Native peoples in our land. That is the U.S. Constitution. But that raises the question of to what set of new principles should we try to steer the court in the 21st century? And that brings me to this new system, this new framework that is established by this UN declaration in 2007. And let me just ask, has anyone here had a chance to read this declaration yet? Raise your hand if you have. Less than a half a dozen. That's about par for the course, because it was passed in the UN in 2007 after more than 20 years in the making. But people are just now starting to read it and understand its import. But essentially what this UN declaration is, it's minimum standards for the survival, dignity, and well-being of the world's indigenous peoples. And it uses human rights as the framework for establishing standards for each nation, and it calls these rights inalienable and thus indefeasible human rights, that are inherent human rights, I guess you could say, that are drawn from the corpus of modern international human rights law, and then taken from that and applied or interpreted in the unique context of indigenous peoples. These standards create, they don't create new rights or special rights for indigenous peoples, but they take their circumstances into context and essentially accord them the same rights that the rest of humanity already enjoys. And this document contains the full range of indigenous aspirations and rights that we see here in the United States. Self-determination, culture, religious freedom, the whole gamut of Native American concerns are addressed and included. This document makes it part of the UN human rights system, and it has set in motion all nations. It asks all nations to go about implementing these standards into their laws and social policies. This document allows us now to envision American Indian rights or Native American rights as inalienable and inherent human rights. The Declaration was 20 years in the making by pioneers, that indigenous peoples that for the first time went to the UN, got a seat at the table, and went through all of the UN processes in a 20-year period, step by step, to ultimate approval by the General Assembly. It passed. All of the nations have voted for it except for 4 in the year 2007. The 4 being the U.S., Canada, Australia, and New Zealand, the hardcore settler states. They've all since then reversed their position and now endorse it. So today there's 150 nations that do endorse it. The whereas clauses on this document, you should download it from the internet, but it talks about the need to provide remedial relief from the legacy of colonialism. It condemns racism in any form as unjust and unfair, and calls for principles of non-discrimination, principles of equality, principles of justice, and democracy and good faith. All these value systems and ideals, from our modern vision of human rights for humanity are the foundation for these rights. And then it goes forward in 46 articles to enumerate these standards. At the core lies the right of self-determination. which has been our policy here in the United States since 1970. But this document, in one way or the other, all of the other rights tie back into the self-determination principle there. So it does present a brand new framework. The promise of this document is great because it could change the world and the way it looks at 270-odd million indigenous peoples around the world. It could, if fully implemented, usher in a new era for indigenous peoples around the world. And it certainly, here in the U.S., allows us to define indigenous rights as inherent and inalienable human rights based on a more just foundation, more appropriate foundation that more closely serves our core American values. And it opens the door to our society to move away from the dark side of federal Indian law into the light of justice, I guess, that would be provided by a human rights framework. And so it in short, gives us an opportunity to pause, take stock of our laws and policies, and ask ourselves how well they have served us in America's treatment of Native peoples, and to enter into a focused national dialogue with Native Americans about the nature and content of human rights for Native Americans. I think that this declaration potentially will have good impacts on federal Indian law, because if you do a side-by-side comparison between federal Indian law and the declaration, we'll find many areas that I look at in my forthcoming book that show where our laws and social policies, as good as they are in the world's leading democracy, do not comport with these minimum standards. And I think that if these standards had been the law when our 10 worst cases were decided and the Supreme Court had to apply them as a part of our American law, the outcomes would have been vastly different. And we would have today no dark side of federal Indian law. And then if we compare that with maybe the 10 best cases of federal Indian law on the vibrant side, some of them are short-lived cases, fleeting, but they show compatibility with these standards. And this, if we could incorporate the declaration, it would make the very best of our legal culture more reliable for Native people that we could bank on when we go to court. But there's challenges, as I conclude here, in implementing this declaration, because it's got a wide scope, calling on our nation for very broad changes in the way we treat Native people in our laws and social policy, especially in our judicial thought. And to do all of this in consultation with indigenous peoples. There's provisions in the Declaration that lay out how nations ought to go about this belated nation building, you know, by incorporating these in consultation with indigenous peoples. But I think it's going to be the work of a generation, similar in many respects to the challenge that was posed to Black America to overcome Plessy v. Ferguson, you know, where Black America had to live under that doctrine for 58 years before Brown v. Board of Education overturned that doctrine. And I think that the NAACP had immense hurdles beginning in 1910 to invent civil rights law, to build a law school, and do everything necessary leading to the Brown decision, which was probably the most important decision in the 20th century that changed the face of America. But for the most part of that period, Black America lived with Plessy v. Ferguson and had to enforce the separate but equal doctrine through litigation, focusing on its more protective side, equalize the schools. And it wasn't until 1950 till they changed their strategy for a frontal assault on that doctrine, leading to Brown. By the same token, Native people with our many Plessy v. Fergusons that we have during the tribal sovereignty movement, we lived with federal Indian law as we found it and tried to simply enforce the more protective features in it. But I think you can only go so far, a race of people can only go so far under an unjust legal regime, and there will necessarily come a time where you have to challenge that legal regime head on. And I think that time is at hand. We have many needs, I think, to implement this, to build a social movement. Obviously calls for lawyers of a certain kind, legal scholarship to help light the way, strategies, money, priorities. All of these are obvious needs. But before that can begin, or at the outset, I think our nation, as a first step, needs to engage in a focused national discourse on the nature and content of human rights for Native Americans. And we've never done that in this nation today. It was avoided during Manifest Destiny. The courts have specifically eschewed justice when defining Native rights historically. And our nation has never had a serious discourse in the same way that we've looked at the questions of slavery and equality for blacks. Rather, we've continued to play cowboys and Indians when it comes to Indians. And there's a number of factors, I think, that have prevented that discourse and might prevent discourse that we have to face and overcome as a people. I think one of the first is, what is this UN Declaration? Isn't this an alien document that comes to us from the international realm? Can't we just look to the Bill of Rights? But I think we have to remember that much of our federal Indian law was shaped by international law. I think another inhibiting factor is, what are human rights? What is this language of human rights that we see on TV, and we deplore violations of human rights, but really, what are they? We're not used to that particular language, but I think we have to remember that human rights is a homegrown American value, that it came to us, I think, in the Revolutionary period. The principles set forth in the Declaration of Independence, are pure and simple human rights. And I think the notions of natural law, that people are endowed with these human rights, were very familiar to that first generation of American leaders. So this is homegrown language that we should be familiar with. And it's true that we have these values, but sometimes we've strayed from them in the course of American history, but these core values have always impelled us to self-correct. And I think that we've done that, however torturous that may have been in our history. But I think we need to do that for Native America to root out these nefarious doctrines. And I think that the third factor, as I race towards conclusion here, is that we just can't face our inner demons as a people that come to us from our legacy of conquest here in the United States, the winning of the West and the Manifest Destiny and the harsh impacts that it had on our native peoples. We don't want to confront these inner demons. We have and I think rightfully so, an inflated self-image. We have, as Newt Gingrich calls it, this American exceptionalism, quite rightly so because of our core values as a people. But our treatment of the Indians impugns our self-image. It impugns our notions of a pure nation, one that has been gone where no other nation on earth, and shows that maybe we have feet of clay. We're not quite so as exceptional as Newt Gingrich would have us believe. And then, judges, as agents of the sovereign, can't really question, can they, the way that our nation was built, because it raises our legitimacy as a nation. But I think we can face all of these, including this old-fashioned guilt, through discourse about the meaning and nature and content of indigenous rights. And through that process and a social movement, we can witness it in our lifetime, I would hope, the rise of human rights in Native America, and we can all walk together in the light of justice. Thank you. I know I've gone long, but I'm able for a few questions as long as they're easy ones.
Thank you so much. That was a very interesting talk and very compelling. Several of my students from jurisprudence are here, possibly walking out right now, but to go to another class. And I thought that your talk was a really good explanation or example or illustration of the tensions between the positive law and natural law. And you brought up the natural law toward the end. So I was wondering where you believe the value, you started talking about this, the values of the human rights, this dignity, things like that. Those values are so important in shaping and saying to the positive law, well, this is not good, we need to change it. But what if you didn't have the UN Declaration? I would assume you would still think that these are important. So where would you look to? The Declaration of Independence is not necessarily a source of law. Would you look to things other within the law itself, or what do you want to look to fundamentally as those sources of natural law?
I would look at two sources. One would be our core values as an American people that hold that all human beings are endowed with certain rights that no nation can take away. And these natural law principles that are in our core values, have taken us to unprecedented freedoms. And as I mentioned, we've not always lived up to them, but when we've taken these detours, these values have always brought us back and impelled a self-correction, if you will. Secondly, I think we can look to international law, international human rights law, because the norms that are found in human rights law or international law, and emerging norms that are being crystallized into norms by reason of this document, are finding wide acceptance around the world. And once you have an international law norm that becomes part of the federal common law that is enforceable by the courts as federal common law, and many of these norms that are these standards that are in this UN Declaration are tied to actual treaties to which the U.S. is a signatory. And even though the courts have said these are not self-executing treaties, when we implement these standards, we are effectuating them as well. So we don't have to look far to implement this, and I think that We just look to our core values and what the rest of the world is doing in the post-colonial world, and bring our courts up to date with that. Something that and let international law, continue to shape it, our federal Indian law. So I'm not saying it's easy, but I think that these provide guideposts of of right conduct, best practices. You can look around the world, and whenever you see a nation that laws and policies don't comport with these standards in this UN declaration, you will see deplorable human rights violations, and I think that we want to hold ourselves out as a human rights champion, but as Dwight Eisenhower said, whatever America wants for the rest of the world, we got to take care of it in our own backyard first, So.
Thank you.
Hi, I just want to echo Professor LaFaso. Thank you for coming. I have about 10 pages worth of notes, but I'm only going to ask one question. So my area of scholarship is on business and human rights, and there's also been a lot of movement in that area on the UN level. So the UN just recently released in 2011 these guiding principles for transnational corporations, and the working group that was established as a result of it actually wants to make indigenous communities a special concern for transnational corporations going forward. And the law school is having a conference on business and human rights in the fall. And so in that light and in that context, what challenges or what advice would you give to people who are trying to implement business and human rights specifically with regard to indigenous communities? Sort of what are the particularized challenges that you see with regard to business and human rights and indigenous communities?
Oh, wow, that's a real tough issue. It's a tough issue because when you're pitting money and greed and the transfer of property and natural resources, these are, I think, the imperatives of colonialism. This one-way transfer of property and one-way transfer of resources from indigenous to non-indigenous hands. And it's a very potent form of what some people would describe as developmental genocide, when it comes to negatively impacting remote and vulnerable indigenous peoples, that don't have the sophistication to deal with the corporation. One example may be this Keystone XL pipeline from Canada that's going through the Great Plains in my neck of the woods down into Cushing, Oklahoma, and on into the Gulf of Mexico, and it's a tough set of legal and political and public education challenges, to protect indigenous peoples from economic exploitation. But it's very familiar. I think we deplore it when we see it, but we tend to have a blind eye to it, I think, in our own country here. Sir?
Your response to that question provides a nexus to the question I wanted to ask. I teach a seminar in human rights and the environment. I've taught courses in environmental justice as well. I'm wondering from your experience, to what extent has American environmental regulatory law, land management law, NEPA, and so forth, provided a vehicle that has been used or can be used by Native Americans to further the interest of human rights?
I think that one of the big challenges in representing Indian tribes is in the environmental realm. Our nation is heir to some of the largest concentrations or pockets of concentrations of the world's last remaining hunting, fishing, and gathering cosmologies that we find in Native America. And those ways of life and the ways that they humans comport themselves to animals and plants and fish and all that goes along with that in the natural world are tied to the indigenous habitats of indigenous peoples around the world. And whenever those habitats are degraded, it impacts the human right. It not only messes up Mother Earth and all of the animals and plants, but the people that live in the natural world and depend upon it for their traditional ways of life, and I think one of the hardest legal challenges in the U.S. is to protect the remaining vestiges of indigenous habitats that are critical to the cultural survival of the surviving hunting, fishing, and gathering cosmologies. And sometimes you can wed federal Indian law with the Endangered Species Act and other environmental legislation to the trust responsibility of the government to force in court the agencies to, like the Bureau of Reclamation, for example, to protect endangered species that are also in indigenous habitats that are also treaty-protected fisheries where the reclamation has a trust duty to the tribes, which has to be taken into account, and often the senior water rights of the tribe over the irrigators. And so at times you can patch together a viable and successful set of theories, to potently affect tribal environmental resources, but it's pretty rare to do that. It's very difficult, very complex, and our law is simply not keeping pace with the rapid technological degradation, of indigenous habitat, and it's not keeping pace with it. And there's certain legal theories emerging in federal Indian law, but it's coming about on too slow a course to keep pace, with that. And I think Congress is going to have to come in. These UN declarations, I think, could help in that area.
My name is Elisa High, and as a native person from this area, I want to thank you very much for coming. I really appreciate the law school for this lecture, and of course Native American Studies for making our interaction with you possible in person. I remember reading the UN Declaration some years ago and kind of being dumbfounded by it, because I looked at it and I thought, this is just so amazing. How come nobody else seems to know about it? Why hasn't it trickled down to where I live? Mm-hmm. And, I probably read it. We were fortunate here. Chief Warren Lyons has been here 3 times. And Henrietta Mann came here. And she seems to be somebody who out in Montana has made a real difference in their school system. Here in West Virginia, we have no federal tribes. We have no state tribes. And we seem to sometimes feel like Native America is always someplace else. It's not here. But we have some real issues, and I just want to thank you again for putting together some of the ideas that you have here. Certainly, a lot has to do with environmental issues. West Virginia is part of we've had some of the greatest resources in the world here. Mm-hmm. And the use and takeover of those natural resources, I know that's a big part of why, in some ways, our native stories here have been lost or just not seen. And I guess I'm rambling here a little bit, and I'll quit. But I just think what you said, it gives me heart, because you don't see anyone. I'm not aware of other people within this state at a governmental level who, for whatever reason, and I'm not blame gaming here, I'm just saying we have some real problems here as far as indigenous rights are concerned, and just trying to reconnect things. And, maybe if we could do more with this UN mandate, it would be a tremendous help. But I've run across very few people who seem to know it. And we certainly don't follow it here as a rule in the state. So maybe with your coming here, we can get more dialogue going and maybe make a little difference. So thank you so much.
I would just say that don't be discouraged, because sometimes the seeds of change, are often unheralded events, little noticed events. Who could have known how the birth of Christ would have, for example, affected millions of people all over the world, or the life of Elvis would have rocked the music world in the course of one lifetime, This was a little noticed event, even though it was a pioneering and landmark development in international indigenous movement and international law, and that, I think, promises to shape a society, or may reshape the world, but these are often little noticed at the time, and it takes a while for it to sink in. I know in Indian country, tribal leaders and tribal attorneys are just now reading it. It's been the subject of some conferences. There's been a Senate Indian Affairs Committee hearing about its implications. The UN Special Rapporteur, James Naya, who's doing the foreword to my forthcoming book, did an official U.S. visit last year in consultation with tribal leaders and produced a UN report containing recommendations as to how the U.S. could go about implementing it, and so... But for the most part, most of us, including myself, attorneys and tribal leaders, have focused on our domestic law and policy as the fora for providing relief, for our clients, and it's just been a few visionaries from my profession that were participated, in this international development. But I do think it is landmark, and I also, as the Dean McDougall was aptly pointing out to me, there's an awful lot of parallels here in West Virginia with your environmental beautiful setting that you do have, the poverty that you do have, and your economic development challenges that you do have with Indian reservations. So there are many parallels there that I think would be fascinating to explore further, between the aspirations and the challenges, between West Virginia and Indian country as a whole, and so. Bonnie?
Thank you. I just wanted to ask, since we're talking about things that didn't get a lot of attention or a lot of focus and many people are not familiar with, I wonder if you would make some sort of comment about the notion of federal apology. We had a small apology tucked into a appropriations bill with President Obama, but and maybe what role you see for formal apology.
Yes. In my forthcoming book, I'm glad you asked that. Part of my book addresses the question, why should we act? Why should we drop everything and do a discourse with Native people? Why do we care? Why should is there a responsibility to heal historical injuries, that may still be with us today? And in part to answer that, I resort to our wisdom traditions. The very finest thinking of the human race teach us, how to heal an injury. Whether it be all of the world religions exhort us, essentially, that when you have injured someone, there are ways that are sure as the rain must fall that you can heal that. And it's a simple 5-step process. It's not rocket science. But first you have an injury. That's number one. Societal trauma, a traumatic event. You have brought harm to another person or a community. Then it's still seen and felt today. The second step is you have an apology. You get on bended knee and you go to that person and you apologize and ask for forgiveness. Very difficult to do. And when you go to D.C. and ask for an apology, it sends everybody scurrying for shelter. Then thirdly, the third step in this healing process is you accept the apology. Also very hard to do. Some victim communities that have suffered genocide and other traumatic events, they simply can't bring themselves to forgive the perpetrators of that. But then the fourth, if you can do that, then that brings you to your fourth step is acts of atonement to make things right. You can't apologize and just simply walk away without cleaning up your mess. You have to have a voluntary act of atonement. And then fifth is the healing that has brought us about. Once you've gone through that, the whole purpose is to reunite communities that have been divided by a harm or a hurt. And I think that these are universal. It's the very best traditions of the human race that have been applied all over the world from the beginning of time. Ours is a history with many injustices, a lot of trauma, a lot of traumatic events, and you can analyze history through the lens of societal trauma, for example. So we have evolved these tried and true principles for healing injuries, and so part of that process is this apology. And there's a lot of elements to this apology that really makes it a healing thing, but it's got to be sincere. There's got to be truth-telling in it. It's got to be genuinely made, and then you have to actually ask for forgiveness. And all very difficult to do, And Congress has passed the Native American apology at the instance of Senator Brownback of Kansas. But the curious thing about it is that it was never extended to Indians, the Indian country. It's a secret little apology that's buried in a 150-page defense appropriations bill. You can't hardly find it if you search for it. And President Obama has met with our tribal leaders on several occasions since that was buried in that bill, and has never once uttered a word of apology. So it's an apology that's been made along this 5-step process, but never extended to Indians, and some people say, well, why did they make an apology and never offer it? So that's where we are along that 5-step process. But if a real apology is made and forgiveness asked, and the burden shifts then to Indian country to accept it and forgive, very powerful. Forgiveness being very, very powerful. Maybe one of the most powerful human attributes is that of forgiveness. The weak cannot forgive, I think. But then once you do that, then we have to then turn to acts of atonement. Those acts of atonement are laid out in that UN declaration. They provide us with a blueprint on how we can not, repair this legacy of conquest and bring Native people into the body politic, with their rights and aspirations of indigenous people intact. So it's an important question. I'm glad you asked that.